my name is Kristen Shaffer. I'm an attorney at Shuttleworth in Ingersoll. I work in our Coralville office and I primarily practice family law. Today we're going to be talking about temporary hearings and family law matters. That would include unmarried and married families as well. So we'll be giving you a very brief overview of what you can expect, mostly for the format of a temporary hearing, not necessarily the content of one. So the relevant chapters for temporary family law hearings will be 598 and 600B. So 598 applies to married families, 600B applies to non-married, but as you will see when you review 600B, that references back to 598. So issues you can ask for in your temporary hearing includes custody, a care schedule, support and maintenance. You might also be asking about school for the child or daycare, in addition to potentially possession of the marital home, but that only has a very limited circumstance where the court can enter orders regarding that. So the structure of these hearings will vary district by district. Some districts will have a more lengthy order. They'll give you a better idea of what to expect. I've included with this presentation an order from the 6th district. I think we have one of the more lengthier orders that gives you a good idea of what the hearing looks like. You may have other districts with a pretty brief order. The 5th district also provides a fairly detailed order as well. So what you can expect for the type of format, you may have a hearing that's affidavit only. For example, I've had hearings in the 8th district when they're support only. It's purely affidavit, even though the order will tell you a date and time for your hearing. You don't actually show up in person. Instead, that is the date and the time the judge will sit down and look at the affidavits in the case. Of course, before you decide not to show up for a hearing, you want to verify with the clerk that it truly is a hearing that's affidavit only if you get an order with a hearing date. In the 6th district, we do our hearings by affidavit and then oral argument by attorneys in the courtroom. Of course, your clients will be present as well, so you should prepare them for potential questions by the judge. It's unusual that they ask them, but sometimes it does happen. It may even be very basic questions such as, what time do you get off of work, in the event that wasn't already in your affidavit. Other districts also have hearings that the clients will testify live at the hearing, but all the witnesses will be by affidavit only. And some hearings are purely live testimony. So the hearings can range from 30 minutes to a couple of hours. That will again vary by district. If you know your hearing is going to require more time than the standard allotment in your district, you need to make sure when you're requesting that hearing that you inform the court you would like more time from the beginning. Otherwise, you may show up to your hearing and they've only given you 30 minutes and that's all you're going to be allowed, even though your case may require more time. A couple miscellaneous things is that temporary orders can be changed prior to a final order in your case. There's limited circumstances for that, so make sure you read 598 to take a look at what circumstances that does apply in the event something with your current temporary order isn't working or wasn't previously addressed. You want to make sure you can actually get the relief you're asking for. Additionally, in your case, a party has to ask for the temporary hearing, so the court won't automatically give you one when you file your case. But you also want to decide, is a temporary hearing necessary? Will it be beneficial to your client at this time? Or should you wait a little bit, see if the parties can figure out an agreement, see if they can get along better, or if the circumstances will improve for your client. But there are some cases where you do need a temporary hearing immediately. And then we'll just briefly go through the different code sections that you'll want to make sure you take a look at. Of course, you should be reading the entire chapters of 598 and 600B if 600B applies to your case. You don't want to overlook something that's in either of those chapters that could be helpful to your client. So 598.10 is the provision for temporary orders. 598.11 includes additional provisions about temporary orders, including changes and retroactive modification. 598.21a talks about orders for spousal support. 21b talks about child support and medical support. 598.33 is orders to vacate. That's for the limited circumstance when you can remove another spouse from the house. That's a very high burden to prove. You have to show that the other party or the children are in imminent danger of physical harm if an order is not entered. Otherwise, you have the situation of two married people who can continue to live in their marital home. And then 598.41 would be custody factors for children. Make sure you take a look at that. Of course, in re marriage of Hansen is also a very important case to make sure you take a look at before any custody hearing happens in your case. And then getting to 600B 25, form of judgment, the contents of a support order, you'll want to take a look at that. And then 600B 40, custody and visitation, 600B 40A for temporary orders. You will see this section will reference you back to 598, of course, as we've already talked about. You also want to make sure if you're asking for child support to read Chapter 9 of the Iowa Court Rules. You also want to make sure your child support software is up to date. There's been changes in the past couple of years to the child support guidelines as well as tax changes. So you want to make sure you're reviewing those provisions and know them well. That way you can use them the best to your ability to benefit your client. Also, a lot of temporary hearings used to be held in chambers in the past, and clients wouldn't have the benefit of being present. The rules of civil procedure were changed, so now all temporary hearings should be held in a manner where your client can be present, whether that's in person or a telephonic hearing, and that's Rule 1.431, subsection 10. And also make sure you're looking at case law. There's a lot of great information you can find looking at other cases that could support your client's case. So make sure you're taking a look at the case law as well, not just the statutory sections. And additional resources that are available, the Iowa Bar Association has a fantastic family law outline. Jim Mead has historically kept that up to date. Again, it's only an outline that kind of gives you some basic background, so you may want to do additional research if your particular case warrants that. Also, Ask an Advocate listserv that we have through the YLD. It's a great way to ask questions, even the ones you might be too embarrassed to ask somebody else about. All of the YLD Executive Council also is very friendly, so reach out to any of us. We're happy to answer any questions you have. And of course, ask attorneys you know. Even if it's your opposing counsel, if you're in a new district, most attorneys are pretty friendly to share information with you, especially now that the local rules no longer are on the judicial branch's website. Some districts are still following those local rules, but it's hard to know what they are since they're no longer available. So thank you for watching this video, and thank you for being a member of the Iowa Bar Association.